Settle down, class. Settle down. Right, let's begin. Welcome to today's explainer of our constitutional law source material. I'm your professor, and today we are tackling a foundational pillar of Indian jurisprudence. Look at the board. Question 26. Explain the basic structure doctrine with reference to cases. Now let me make one thing absolutely clear before we go any further. This, right here, this is a guaranteed 16-mark examination question for your KSLU finals. Guaranteed. If you want to clear this paper, you need to pay strict, undivided attention to how we dissect this text today. So take out your notebooks, sit up straight, and let's dive into the mechanics of securing maximum marks. Here is our agenda. 1. Introduction. 2. Meaning of doctrine. 3. Evolution through case laws. 4. Elements. 5. Importance. And 6. Conclusion. Mark my words, this exact sequence is the mandatory skeleton you must memorize and replicate on your answer script to secure maximum marks. Let's move on.
Section 1. Introduction. This is where we set the foundation of your answer.
Constitution gives Parliament power to amend under Art 368, not absolute. Basic structure doctrine limits altering core features. Okay, let's dissect this. In your exam, when you write this introductory paragraph, I want you to literally take your pen and heavily underline Article 368. Make it jump off the paper. You want to instantly capture the evaluator's attention. What you're doing here is establishing the fundamental conflict. Article 368 grants the power to amend, but, and this is a big but, the basic structure doctrine acts as the ultimate judicial brake on that power. It literally stops the Parliament from rewriting the Constitution's very DNA. Moving on to Section 2, Meaning of Basic Structure Doctrine. Look at the points here. First, Parliament can amend but cannot destroy or damage basic structure. Second, term not defined in Constitution. Third, developed through judicial interpretation. Class, pay attention, because I must elaborately warn you here. That second bullet point, it's a tricky trap where so many students just lose marks. You must heavily emphasize to the examiner that the term basic structure exists nowhere. I mean, absolutely nowhere in the literal text of the 1950 Constitution. It is entirely a judicial creation. It's like an invisible shield forged by the Supreme Court over decades. If you forget to mention that it's developed solely through judicial interpretation, well, your answer is simply incomplete. Next heading, Section 3, Evolution through case laws. This, class, is the absolute heart of your answer. Before we read this, I command you to create a separate, boxed heading for these cases on your answer sheet. Without case laws, your answer is just an empty opinion. Let's read. Shankari Prasad v. Union of India, Parliament can amend any part, versus Golak Nath v. State of Punjab, fundamental rights cannot be amended. Right, let's perform a deep breakdown. For a 16-mark answer, just naming them won't cut it. In Shankari Prasad, the brief background is that the very first constitutional amendment was challenged. The final ratio decidendi, or verdict of the court, was that Parliament's amending power under Article 368 is supreme. It can amend anything, even fundamental rights. The absolute relevance here is that it established Parliament's early dominance. But then, fast forward to 1967, Golak Nath. The background here? A challenge to the 17th Amendment concerning property rights. An 11-judge bench delivered a frankly shocking verdict. Fundamental rights are transcendental. They cannot be amended by Parliament under Article 368. Do you see the extreme tension here? Shankari Prasad granted unlimited power. Golak Nath strictly prohibited touching fundamental rights. This massive constitutional clash set the stage for the most important case in Indian history. Exam tip. Explicitly contrast these two cases just like this before introducing the climax. And here is that climax. Read it carefully. Kesavananda Bharati v. State of Kerala, Supreme Court laid down basic structure doctrine. Parliament can amend the Constitution but cannot alter its basic structure. Pause right here. I demand you draw a physical box around Kesavananda Bharati on your exam paper. Write down the year right next to it, 1973. What's the background? His Holiness Kesavananda Bharati challenged Kerala's Land Reform Act, which culminated in challenges to the 24th, 25th, and 29th Amendments. A historic 13-judge bench, literally the largest in Supreme Court history, sat down to resolve that Shankari Prasad and Golak Nath conflict we just discussed. The final ratio decidendi? By a razor-thin majority, 7-6, the court held that yes, Parliament can amend any part of the Constitution, including fundamental rights. But it cannot alter the basic structure or framework of the Constitution. The absolute relevance of this case is that it's the ultimate legal compromise. It gave Parliament its power back, but drew an uncrossable line in the sand to protect the Constitution's soul. Let's sequentially read these post-KESAVANANDA developments. Treat this table as your perfect exam cheat sheet. First row, Indira Nehru Gandhi, free, fair elections. The background here was a challenge to the 39th Amendment, which tried to place the Prime Minister's election beyond judicial scrutiny. The verdict? The court struck it down, cementing free and fair elections as basic structure. Its relevance? It proved the doctrine could actively strike down abusive political amendments. Underline this case to capture the KSLU evaluator's attention. Second row, Minerva Mills, limited amending power, balance of FRs and DPSPs. Listen carefully, class. The background was the infamous 42nd Amendment, trying to give Parliament unlimited power. The verdict deeply analyzed the harmony between fundamental rights and directive principles of state policy. The relevance of Minerva Mills is paramount, okay? It stopped Parliament from legally converting a limited amending power into an absolute one. Third row, Waman Rao, ninth schedule. This simply clarified the cutoff date for applying the doctrine, which is April 24, 1973, the exact date of the Kesavananda judgment. Let's move on. Section 4. Elements of Basic Structure. Let's read the list. Supremacy of Constitution, rule of law, separation of powers, judicial review, federalism, secularism, free and fair elections, independence of judiciary. Listing these elements cleanly is non-negotiable for a complete answer. The Supreme Court decides what constitutes the basic structure on a case-by-case basis. You must rapidly memorize this list. To secure full marks on this question, you have got to reproduce at least 6 of these on your script, and preferably in neat bullet points to show the examiner your clear mastery of the legal data. Down to the penultimate section, Section 5, Importance of Doctrine. This shows the evaluator you understand the why behind the law. Let's read these points. Prevents misuse of amending power, protects core values of Constitution, maintains balance between flexibility and stability, ensures constitutional supremacy. Class, I passionately urge you to grasp this. Highlighting the importance shows the evaluator you don't just blindly memorize cases, you actually understand the jurisprudence. These specific justifications are exactly what protect the Indian democratic framework from descending into totalitarianism. By maintaining a balance between flexibility, allowing the Constitution to adapt to new times, and stability, preventing ruling parties from destroying the rule of law. This doctrine acts as the ultimate guardian of the people's rights. Finally, Section 6. Conclusion. Conclude your exam answer with strength and clarity. Cornerstone of Indian constitutional law ensures essential identity remains unchanged while evolving, safeguarding democracy and rule of law. Write this out clearly. Never leave a 16-mark essay hanging without a solid conclusion. Now, before I dismiss the class, let me end this explainer by asking you a provocative, exam-level question to ponder. If the basic structure is truly nowhere written in the Constitution, does this judicial doctrine ultimately safeguard democracy, or does it simply transfer supreme, untouchable power into the hands of unelected judges? Think critically about that balance of power as you prepare your notes. Class dismissed. Study hard.